Disclaimer. All audio recordings, phone calls, and in-person interactions presented in this documentary were lawfully obtained pursuant to 720 ILCS 5:14-3, a statutory exception under Illinois law that permits recording a conversation without the other party's consent when the person recording has a reasonable suspicion that a crime is being, has been, or is about to be committed against them or a member of their household.
The recordings used herein were made for the sole purpose of documenting what I reasonably believe to be criminal acts of coercion, retaliation, official misconduct, and obstruction of justice by government officials acting under color of law.
This is not only a protected activity under Illinois law, it is a necessary act of self-preservation in the face of unchecked authority.
After serving more than a decade for this fraudulent conviction and about 90% of supervised release, this happened.
Lost in limbo. For nearly 2 years, John Spencer's probation officer went silent. No replies to housing, employment, or travel requests. Spencer kept reporting and paying restitution. No guidance, no feedback.
Silence in the face of full disclosure. During the long void of supervision, Spencer sent letters, emails, and made calls, seeking permission to move, work, and disclose his use of legal hemp-derived THC. He cited the 2018 Farm Bill and AK Futures LLC versus Boyd Street Distro, LLC, which confirmed that hemp-derived cannabinoids are not controlled substances if compliant with federal law. I disclosed everything, including the law. No one responded. Hemp-derived Delta-8 THC products that comply with the 2018 Farm Bill's definition of hemp are not controlled substances under federal law, even if psychoactive. No officer, no guidance, no responses.
Early termination request triggers a reaction.
Spencer reiterates his ask for early termination, and then, suddenly a new name appeared, Officer Leslie Cole. Within days, she called him in for a meeting.
Silence breaks. New officer, new pressure.
From meeting to ambush. At their October 7, 2024 meeting, Spencer again requested early termination. Instead, Culp demanded a drug test, his first in years. Before we talk about early termination, go pee.
During my meeting, I inquired about early termination, noting that now I only had approximately 5 months left on supervised release. In response, Culp immediately ordered a drug test, despite the fact that I told her, or attempted to tell her, I had not been tested in years. No more tests unless reasonable suspicion of use, one PO said. I had never failed a test. I had already completed all 3 mandatory drug tests in Minnesota before transferring to Illinois. Any more were supposed to go through the court, I stated. I objected, explaining that my previous PO had confirmed my compliance with all required drug tests before my transfer, and my conditions said after 3 tests the court determines if more are necessary. Culp says,
that doesn't matter. Well, that doesn't matter, we need 1, and if we're going to approve early termination, my supervisor in the court will require it. We also need 1 year of continuous compliance with no violations.
Leslie, I just want to clarify what I am trying to say. Although I am not taking any controlled substances, there is a chance that I could test positive for THC.
Spencer, thank you for disclosing that. We will have to wait for the test results, but you know that you are not allowed to use any THC products.
These are legal THC, CBD gummies that I use as part of a supplement regimen. The strongest ones I use are for sleep and appetite control.
Spencer, that's nonsense. You can't use THC. You just admitted to me, before the test results came in, and I'll keep that in mind. You came to me with this information yourself.
But listen, I disclosed this before. My previous PO never prohibited me from using THC gummies.
I don't know what you think Officer Lococo told you, but you know you are not allowed to use THC products. Doing so is a violation of your conditions. A failed test is a failed test, you know that. And you voluntarily admitted this to me.
Wait, came forward. If the test comes back positive, then what? What does that mean for early termination? Are you going to deny it? And will I have to start doing more tests or be placed on color code call-ins?
That would be up to my supervisor. But I can tell you that if the test comes back positive for THC, we will not support your early termination. Like I said, we require 1 full year of continuous compliance, and a positive test would not meet that requirement.
There is a difference between controlled substances and legal THC or CBD products that contain THC.
Culp, interrupting. There is no such thing as legal THC for someone on supervised release, period. No one from this office has approved your use of any THC products, and we wouldn't approve it. Federally, marijuana has not been legalized, so we don't even approve doctor recommendations for medical marijuana. A failed test is a failed test, and you have now admitted to using cannabis or THC.
No, I didn't admit to that. But just so I understand, if I test positive, you won't support my early termination, and it will be considered a violation. You will notify me when the test results come in, right? What happens next?
Let's not get ahead of ourselves. We don't have the results yet. I will notify you when they come in. If the results are positive, we will address the issue at that time. I will make a note that you disclosed this information to me in advance and admitted to using, as you put it, THC gummies.
Okay, and if I fail the test, then that means I can't get off paper?
A failed test is a failed test. We're not necessarily going to place you on color code call-ins, but we would not be able to support early termination because we require 1 year of compliance and that would violate your probation. You need to discontinue all use and possession of any THC products today. Get rid of them, and I will notify you when I get the results. Don't worry about it until then.
But I will worry. I have been worried. I want to get off probation. This is very troubling to me. So, you're saying that when you receive the test results, you will call me? And if I fail, as you put it, you will share those results with me, and we will discuss a resolution. Is that correct?
Yes, I will call you when the results come in.
How long will that take?
Test results usually come back in a few days, about a week at the most.
Okay, just to confirm, when you get the results back, probably within a week, you will call me. And if I fail, will I be able to see the test results?
Yes, when I receive them, I will call you.
Okay, thank you. I appreciate that. I will wait for your call.
Goodbye. The legal use that became a legal trap.
Spencer disclosed legal, hemp-derived THC use. Culp said there's no difference between legal THC and a banned controlled substance, even though Spencer's use was lawful under the 2018 Farm Bill. Legal hemp equals violation? Not in the law, only in her head.
Evidence denied.
Spencer asked to see his drug test results. Culp promised, but never delivered. Instead, she ordered him to get rid of everything, destroying the very evidence of his legal use.
Test results promised, never shown, evidence erased.
Coerced confession, or not?
On November 7, Culp gave Spencer 90 minutes to sign an admission. He wrote 2 versions, both clarifying his use was legal. She ignored his denials and claimed he confessed.
Forced forms, falsely framed. November 7, 2024 coercion and procedural misconduct by Culp.
This factual accounting details the communications and interactions between John Spencer and US Probation Officer Leslie Culp. Initial contact, November 7, 2024.
On November 7, 2024, Culp unexpectedly emailed and texted me multiple times, demanding that I call her immediately.
Shortly thereafter, Culp followed up with a text message at 1:47 p.m., reiterating her request.
Culp, text at 1:47 p.m. Hi John. Can you give me a call? Thanks.
Spencer, via text at 1:48 p.m. Yes. In a couple of minutes, I'll call you. Thanks.
Culp, text at 1:49 p.m. Thanks. Phone call, 1:53 p.m. to 2:07 p.m.
Phone call transcript.
Spencer, placing call on speakerphone. Hi, Leslie. I'm working, so I need to put you on speakerphone.
Well, we got the test results back, and they were positive. So, as we discussed, that's technically a violation of your probation.
Wait, when did the results come in? You told me back on October 7th that the test results would take only a few days, and you would notify me as soon as they came back. This has been causing me stress.
The results actually came in a few weeks ago, but I needed my supervisor to sign off on them first.
Why did you need your supervisor to sign off? Why couldn't you just tell me when you got them?
Well, the truth is, I went on vacation, so I'm calling you now. Escalation and retaliatory threats.
Wait, you told me not to worry about this, that we'd deal with it when it came in. I didn't even expect to be tested since my previous PO said testing only needed to happen from here on out with some sort of reasonable suspicion. I was only using legal CBD gummies that contain THC. They knew that, and so did you. Now you're saying it's a violation?
You admitted to using them, so there's really nothing to argue about here.
When I called her at 1:53 p.m. she stated,
My test came back positive weeks ago.
but she had not informed me.
She needed her supervisor's approval before telling me.
The delay was because she
Had been on vacation.
When I objected, stating that she previously assured me I would be informed immediately, she became defensive and dismissive. Admitted to what? I told you I used legal CBD gummies that contain THC. That's not the same as admitting to using an illegal controlled substance.
Culp, interrupting, I'm not even going to entertain that. If you want to deny that you were using illegal drugs, which is against your probation conditions, then we can escalate this to my supervisor and proceed with a formal violation. Is that what you want?
That is not what I said.
Culp, interrupting again, I thought when you were honest about it, that was a good sign for you. Now you're trying to say you didn't do it? Either you did or you didn't, which is it? Because we can just take this to my supervisor and initiate formal violation proceedings.
I don't even see how any of that is necessary at all. This is completely different from what you told me before. You said we'd handle it when the results came in, but now you're saying I admitted to something I didn't, so I will definitely contest that I used any controlled substances.
I said that if the test comes back positive, we're not going to support early termination. You'll need to stop using the gummies, discontinue all use and possession of any THC products, and we'll have to retest you again to make sure you're in compliance. And you already agreed to discontinue using them.
After shutting down my attempt to clarify the situation, Culp abruptly demanded that I sign a document that same day.
You're going to discontinue using the gummies, which you already agreed to do, and we'll see where it goes from here based on today. I'm going to forward you a document that you need to sign. It has to be signed today because it's the last day I have to submit it.
Feeling frustrated but measured, I said to Culp, I need to review it first. What is this document exactly?
It's the admission or denial form for the drug test results. Like I said, you already admitted using THC, so I don't see what you are trying to change in your story now. You admitted it to me already.
You're asking me to sign something without letting me see the toxicology report? You won't even discuss my explanation? That doesn't seem right. You were supposed to get back to me weeks ago, then you went on vacation, and now I need to sign this? I will have to mark down or document that this is happening.
Culp, impatiently, I need it signed today. By 4 p.m. I'm telling you, I'm not asking you. If you want to try to change your story now, we'll deal with it, but I still need that signed today by 4. I thought you were displaying good character when you came forward and admitted the THC use. Now it sounds like you want to change your story?
I'm not changing my story. You're saying I violated my supervised release conditions, and I am saying that I did not possess a controlled substance. I told you that. How does my story change at all?
Listen, I'm not going to debate this with you. You said you used THC products, right? You agreed to get rid of them and stop using them. Whatever explanation you want to add, go ahead and add it. But you know as well as I do that you cannot use any THC products on probation. We're done here. I will send you that form, Mr. Spencer, and I expect it by 4 p.m. Pressure to sign the document.
2:08 p.m. to 4:50 p.m.
After my phone call with probation officer Leslie Culp, which by the way, ended at exactly 2:07 p.m., she immediately followed up via email at 2:16 p.m., attaching the admission denial form and stating,
Culp, email at 2:16 p.m.
Thanks, Mr. Spencer. Per our conversation, I've attached the report for the positive urinalysis for you to either admit, deny. Please return to me today.
This was an attempt to create urgency and pressure on me to comply without any opportunity to seek legal counsel.
Escalating pressure from Culp. At 2:54 p.m., Culp sent another email, pressing me further.
Hi, did you receive the email? Just checking, thanks.
At 3:08 p.m., I responded, yes, working on it now. Thanks, I understand you need this today. Got you.
At 3:10 p.m., Culp reinforced the 4 p.m. deadline, stating,
Yes, by 4 p.m. Thank you.
At this point, I was given only 105 minutes to sign a confession or face the risk of escalation to a supervisor-enforced violation.
Breakdown in communication, 3:58 p.m. to 4:50 p.m.
As I attempted to comply, technical difficulties delayed my ability to send the signed document. Rather than allow a reasonable resolution, Culp escalated her tone, becoming impatient and accusatory.
At 4:01 p.m., Culp texted,
I'll look for it, haven't received it yet.
At 4:03 p.m., she continued pressing, texting,
Still haven't received it. Can you screenshot, please?
At 4:46 p.m., Culp called me and immediately became openly hostile, stating,
I mean, this isn't even a hard task. This is a simple task. I'm asking you to do something simple, and you're refusing. I'm asking you to send an email, just an email, and you can't seem to even figure that out.
At 4:50 p.m., I sent 2 images of the signed document, the same forms I had already sent via email, in an effort to de-escalate the situation.
Despite the unnecessary pressure and hostility, Culp did not acknowledge receipt until the next day. November 8, 2024, at 12:03 p.m., when she finally responded. Culp, email at 12:03 p.m., November 8, 2024.
In receipt, thank you.
In February 2025, Spencer was summoned for another drug test, again without any probable cause or explanation. Still no test results, just more pressure.
Second test, no answers, same pattern.
February 20th, 2025. Probation drug testing held with no resolution on prior disputes. March 3rd, 2025. Spencer summoned again. He contends this was an unlawful detainment. Mar 6-7.
Hi, this is Leslie Culp with US Probation. I'm sorry I missed your phone call. Please leave a brief message and I will try to return your call as soon as possible. If this is more urgent, feel free to contact our office at 312-435-5700 and ask to speak with the post-conviction duty officer. Thanks much. Bye-bye.
Hi Leslie, this is John Spencer. The reason for my call today is because it's March 6th, 2025, and as far as I know, I'm still on supervised release. And from what Mr. Holmes has told me, you are still my assigned probation officer. So given that and given that reality, I need to get immediate clarification on some pressing concerns, right? So I'm actively seeking guidance here. I don't want to have any missteps. Now, under federal law, I believe that I'm entitled to clarity on my supervised release conditions. And what I'm seeking clarity on is your directive that I cannot possess or use illegal THC products. And that if I do, I'm in violation of my supervised release conditions. Can you please tell me exactly what provisions so I know that you're looking at, that you're saying that my release conditions prohibit and restrict that? Since I'm still under supervision and under your direct authority, Leslie, I need this guidance now, not later. So if that's still your position, please be absolutely clear on that your position is I cannot legally possess or use legal hemp-derived THC products, despite the fact that I personally cannot find any of those conditions in my supervised release documents myself. And then you cut out, so I will follow this up with an email. Thank you.
Spencer contacts Marcus Holmes and the probation office for clarification.
Excuse me 1 second. Hello?
Hi, Marcus Holmes?
Yes.
Hi, this is John Spencer. How are you?
Good, how are you?
Good.
I'm out of town. I'm going to have to call you. I'm out of town at the conference. Can I call you back?
Would you, though? I really need some guidance on my conditions. I've emailed them to you, and, there seems to be some controversy, as you might be aware.
Yeah, I've been out at a conference all week, Mr. Spencer, and I don't know. I know you had a meeting with the supervisor and the officer, but I can follow up with you when I get back in town. I'm literally walking across the street now, so I'm not in a position to talk. I'm sorry.
Okay, would you recommend I call the duty officer at your office?
Yeah, you certainly can.
Okay, thank you.
Bye.
You have reached the Federal Supervision Office for the Northern District of Illinois. To continue in English, press 1. To continue in Spanish, press 2. You have reached the Federal Probation Office for the Northern District of Illinois, located at 330 South Dearborn Street, Suite 3400, Chicago, Illinois, 60604. Our hours of operation are Monday through Friday from 8:30 a.m. to 5 p.m. Central Standard Time. Please note that we are in observance and will be closed on all federal holidays. Please listen to the following menu options. Press pound to locate the employee by last name, or press 0 to reach the receptionist. Wait while I transfer your call.
I press 0.
Good morning, probation.
Hi, I'm calling for the duty officer.
Good afternoon. In reference
To my probation.
to your probation, you're currently on federal probation?
I am. Who am I speaking to?
The front desk. Who's your current officer right now?
My current officer is Leslie Coop, but who are you? I want to document that I'm speaking to you.
The front desk reception at the time.
And your name is what?
Front desk.
Okay, so you're refusing to give me your name. All right, I just
did. I said Dawson.
Can you spell that for me, please?
D as in David, A-W-S-O-N. And you're not speaking to Ms. Colt. You are the superior duty officer. Have you tried online?
I have. In fact, we have some ongoing disputes. And Marcus Holmes did I got that right? Mr. Holmes? Yep, he's out of town. I just talked to him and he told me to call the duty officer. But my real thing is that I'm looking for some guidance from my probation officer. And I need some specific guidance from here, but I can't seem to get her to respond to me. A number of emails, now some phone and text messages, and she just seems to not want to get back to me.
Okay, let's try duty. Let's see who's available. Ms. Brittany Quintanar. Hold on a moment, transfer the line.
Thanks.
Probation is Brittany.
Hi, Brittany. I was referred to you first to your office by Marcus Holmes, who told me he's out of town right now and can't talk, but he recommended that I call the duty officer, and then now I'm talking to you. My name is John Spencer, and I am a person under federal probation with about 2 months left under Leslie Culp's caseload. And we have a number of things going on, including some court filings and things, but she has not gotten back to me on any of the things that I've asked. I've asked for a number of clarifications about my supervision conditions, specifically some of the provisions in there. I've asked for some information from my case, and today I followed up those emails and prior phone calls with some more phone calls and requests, but I can't seem to get a hold of that, and I need this information.
Okay. What was your first name again?
John.
John. John Spencer, what's your date of birth?
19, none of your business.
Okay. Let me see something here. Okay. I do see that Ms. Holt has been getting your emails, and she has been speaking with our chief and supervisor, so I'm sure that she'll be getting back to you. But is there something specific that you need clarification on?
Yes, I do. I need something very specifically clarified. But this is the basis, right? Because I have a legitimate concern that more unlawful action might actually be taken against me, not because I'm actually violating my actual supervised release conditions, but because you guys think I might be actually exercising my legal right. So that's my biggest problem right now, and whether I file for a TRO. And it's very urgent and necessary because given that you guys have said there's no difference between legal hemp products and controlled substances, and you've taken a number of punitive acts against me on that pretense, I want to know, as it stands today, March 6th, is that still your position?
So I can't speak into the position because I don't know your case.
Why don't I send you over to your email, since you're a probation officer, my actual conditions, and you can help me look for in there where it says that.
Well, any controlled substance is considered a violation of
Sure,
the condition.
a controlled substance. Now, do you know that there's
marijuana is considered a controlled substance.
It is, but legal CBD is not.
Okay,
Legal hemp is not. And that is a violation. You're still maintaining. That's what your position is, correct?
If you have additional concerns, you can definitely reach out to your own attorney and speak with your attorney about that.
Well, of course I can. Of course I can. But under federal law, you have to be clear about it with me. And I've asked you to look into a specific condition, not just what you think, but what the judge actually ordered. And it sounds like you're refusing to do that, and you're standing by your general statement that I'm not in compliance right now, which is all I was trying to verify with someone from your office.
Okay, again, I'm sure
Thank you.
has written reports to the court. You can always contact your attorney.
Of course I can. Of course I can, but I'm on probation and you still have to do your job. So of course I can do all those things. Can I ask what your point is when you tell me that I can do all those things, when you guys are required to provide me with the answers to these questions, not be evasive and be clear about them?
Again, it seems like Nicole has spoken with you about this. I am not the probation officer assigned to your case. So if you have further questions, you can contact Nicole or you can contact your own attorney about it.
Okay, and so you're telling me that not Pam Bondi's office, not anyone higher, there's no escalation process internally for this? I'm stuck with just arguing with Mrs. Culp according to you?
I mean, you can always be transferred to the duty supervisor, but I'm sure the duty supervisors will be telling you the same thing.
Well, let's let them tell me the same thing. I'll get their name and I'll get them to tell me the same thing. I think that would be well worth my time.
Okay. Can I get a good phone number for you and I'll have them call you?
I'll hold. You said I could be transferred.
I don't have the ability to transfer you.
Okay, sure. I'll give you my
Yes,
I'll give you my phone number. It's 312.
It's 612, none of your business. Oh, you hear me.
All right, I'll have someone get in contact with you. Okay.
Okay.
Like I said, someone will be in contact with you, okay?
Thanks.
Hi, this is Leslie Culp with US Probation. I'm sorry I missed your phone call. Please leave a brief message and I will try to return your call as soon as possible. If this is more urgent, feel free to contact our office at 312-435-5700 and ask to speak with the post-conviction duty officer. Thanks much. Bye-bye.
Hi, Leslie. This is John Spencer following up with you on your email, which is hard to read and doesn't really say a whole lot. You've cut and pasted some conditions that you purportedly say talk about THC, which you continue to call cannabis. What you don't have, is anything clear on here how you're relating controlled substances and legal THC use, which is my specific question. So I'm looking for information on why you think one act of Congress that defines controlled substances and another act of Congress which defines legal THC products, why do you believe one is valid and the other is not? Please offer some reasoned information on that. Very hard to read your email. I'm not even really sure what you're trying to say in your email, the way you've cut and pasted that. Very sloppy.
What happened next in the timeline and contexts is nothing short of amazing.
No condition prohibits legal THC. Spencer's supervised release conditions prohibit only unlawful use or possession of a controlled substance. Judgment language: the defendant shall not unlawfully possess a controlled substance. See Amended Judgment 10-326, 2018 Farm Bill, 21 U.S.C. Section 802, 16, excludes hemp-derived THC as less than or equal to 0.3% delta-9 THC from Controlled Substances Act. Spencer's use involved gummies containing legal levels of hemp-derived THC. Culp's attempt to expand conditions equals legal overreach. Probation's position that any THC use is unlawful contradicts Federal Law, 2018 Farm Bill, 7th Circuit Authority. United States v. Home, 326 F3D 872. Or 2003, supervised release conditions must be strictly construed. Courts may not expand terms beyond their plain language. United States v. Gibson, 356 F3D 761, 765, 7th, 2004.
Probation's unilateral expansion to include legal THC use is legally unsupportable.
Rule of lenity requires narrow interpretation. Even assuming ambiguity, the rule of lenity resolves it in Spencer's favor. United States v. Evans, 659 F3D 788, 794, 7th 2011. Ambiguities in criminal sanctions must be interpreted in favor of the accused. Spencer's conditions do not expressly prohibit hemp-derived THC. Prohibition is invalid.
No reasonable suspicion equals no legal test. Spencer made full disclosure of legal hemp use multiple times, October 7th, November 7th, February 20th. No articulable suspicion existed. Probation's own silence confirms that. Testing done solely because Spencer asked for early termination, not due to violations.
Due process violation, no fair notice. Grained vs. City of Rockford, 408 U.S. 104, 108, 1972, no punishment without clear notice. United States vs. Ortiz, 95 F3D 1050, 11th 1796, vague or uncommunicated conditions cannot be enforced. Spencer repeatedly requested clarification, yet probation refused to respond until post-litigation. Imposed drug tests and restrictions retroactively.
Spencer's exhaustive efforts to get answers from probation. Spencer repeatedly called, texted, and emailed his probation officers, including phone calls to Marcus Holmes, who claimed to be unavailable. Follow-up call to the duty officer. Final escalation to Officer Brittany, who reiterated a blanket, no THC, policy but refused to cite any condition.
Despite months of silence from probation, Spencer continued to submit monthly reports and seek clarification on the legality of hemp-derived THC products, the number of drug tests required under his conditions, whether the sudden enforcement actions were authorized by the court. Probation refused to provide any policy or answer, causing Spencer harm, and leaving him in constant uncertainty about his rights and obligations. Why, despite restitution payments, was his balance still the exact same as in 2013? What is my claimed restitution balance?
Letter to clerk shows pattern of abandonment and post hoc justification.
Mailbox March 7, 2025. Letter to Clerk of Court, Thomas Bruton. Spencer submitted a formal letter requesting the docketing of his email chain with probation as evidence in support of his motion for summary judgment and TRO.
In the letter, Spencer documented months of ignored requests to probation officer Culp for legal clarification. The first ever explanation from Culp, sent only after Spencer filed for court intervention on March 6 at 4:31 p.m.
March 6 equals post hoc justification. Agencies may not penalize citizens under interpretations never disclosed beforehand. Christopher vs. Smith-Kline, 2012, post hoc enforcement equals due process violation. Culp's March 6 email was the first time she articulated that legal THC was banned, after Spencer had already been tested and punished.
Probation acted without court authority. Condition requires drug testing as determined by the court. Culp ordered tests 4 to 6 without court approval. Spencer had already fulfilled his minimum drug test obligations. No order modifying his conditions exists. Unauthorized testing equals unlawful expansion of supervision powers.
Coercion, threats and admission under duress. Spencer was told to get rid of the THC or face consequences. He was coerced into signing ambiguous or false admission forms under threat of further violations. Spencer signed 2 forms, both disclaiming illegality. Probation mischaracterized this as an admission.
The harassment continues.
Seeking justice, not supervision.
After months of intimidation and no due process, Spencer filed for early termination. At this point, only 75 days remained on his release.
88% served, 0% guidance. Enough was enough. When silence returns, this time from the court.
The bigger question.
Was Spencer's lawful conduct used as a pretext to retaliate for asserting his rights? Or to cover up the negligence of a system that left him unsupervised, unheard, and unprotected?
When asking for freedom triggers punishment, something is wrong. Non-exhaustive list of federal and Illinois state law violations committed against me. Bivens action, constitutional violations by federal officers, Bivens vs. 6 unknown named agents, 403 U.S. 388, 1971. Fourth Amendment violations, unlawful detention and coercive drug testing. Fifth Amendment violations, retaliation, falsification of records, and denial of due process. First Amendment violations, retaliation for exercising my right to petition the court for early termination. 18 U.S.C. Section 242 deprivation of rights under color of law, federal felony, probation officers knowingly enforced a non-existent condition, an illegal THC ban. Coerced compliance through a retaliatory drug test after ignoring my prior legal disclosure. Threatened me with further punishment unless I admitted to a violation I did not commit. 18 U.S.C. Section 1519 falsification of government records, federal felony, probation altered or omitted official records regarding my legal disclosures. Falsely documented that I admitted to a violation I explicitly denied. Obstructed my access to my own drug test results to prevent me from challenging their claims. Federal Tort Claims Act, FTCA, false imprisonment, malicious prosecution and negligence. Unlawful detention during interactions with probation, negligent supervision in failing to adhere to legal procedures, malicious prosecution through fabricated drug test claims and retaliatory enforcement.
Illinois state law violations. Official misconduct 720 ILCS 533 3, Class 3 felony, knowingly performing acts forbidden by law while acting in an official capacity. Falsely representing legal authority, e.g., inventing a non-existent THC prohibition. False imprisonment 720 ILCS 5/10-3. Unlawful restraint against my will without legal justification. Civil conspiracy to violate constitutional rights, Illinois common law, coordinated misconduct between probation officers to falsify records and enforce unlawful conditions. Intentional infliction of emotional distress, Illinois common law, deliberate and malicious use of false records to justify punitive actions, use of coercion, intimidation, and deception to manipulate compliance.
Culp's demand for immediate document signing. Wait until you hear a live hearing. You'll never believe it. March 18, 2025. Even the courts involved.
Even the courts involved.
After Spencer's motion, the court abruptly struck the requirement for a government response, refusing to rule on key filings and due process claims. A hearing followed.
Okay, so it is Tuesday, March 18th, and we have a hearing scheduled. The court will discuss the process for resolving the motions 3 and 6. 3 is Spencer's motion for early termination of supervised release, and number 6 is a discovery motion pertaining to that motion. To join the telephone hearing, please dial 650-479-3207 and enter access code 23159967380 pound. Press pound when prompted for an attendee number. Person's granted remote, so I'm going to call that now.
Welcome to WebEx. Enter your access code or meeting number followed by pound.
Case number 20 cr-00697 for evidentiary hearing. Postmark.
Good morning, it's Mark Pacold. Good morning. The United States District Court for the Northern District of Illinois is now in session. The Honorable Martha M. Pacold, 20 cr-697, United States versus Spencer. If you can state your names for the record, we'll start with government counsel first. Good morning, Your Honor. United States. Sorry, we couldn't hear you. Good morning, Your Honor. Ashika Desai on behalf of the United States.
Dale Carnegie said,
And I'm John Spencer on behalf
most
of
the
myself.
important things in the world have been accomplished by
Good
people
morning.
who
Good
have
morning.
kept on trying when there seemed to be no hope at all. Arise, champion. Now, perseverance transforms average, everyday people into world champions. So the key to victory, the key to